here's what we're moving some stuff around. We're going to go ahead and open up, and I'm going to tell you a little bit about today's speaker. Jeff Tenenbaum is one of the nation's leading nonprofit attorneys and also is an accomplished author, lecturer, and commentator on nonprofit legal matters. As managing partner of the Washington, D.C.-based Tenenbaum Law Group, he counsels his clients on the broad array of legal issues affecting trade and professional associations, charities, and other nonprofits. For 19 years, he's practiced law at the Venable Law Firm and chaired its nonprofit practice for most of that time. Among numerous other honors and awards, Jeff was the 2006 recipient of the American Bar Association's Outstanding Nonprofit Lawyer of the Year and is one of only 5 lawyers in the prestigious U.S. Legal 500's Not-for-Profit Hall of Fame. Well, aren't we so lucky to have him today?
Thank you.
Well, I'm going to go ahead and make myself disappear and let you take it away.
Thank you very much. And good afternoon, everyone. Welcome to our webinar today. So today we're going to be talking about virtual trade shows and unrelated business income. Very exciting topic. I joke because the topic, you can see the title of this very exciting book that I wrote, Association Tax Compliance Guide, that ASAE published. Not exactly the biggest page turner that's available on Amazon, but it is an area that I've always done a lot of work. As you just heard, I have spent my 25-year career in private practice of law, all of it representing exclusively associations and other nonprofit organizations. I deal with a really broad array of all the different legal issues that associations deal with, including, of course, the tax issues that they deal with. And one of the primary tax issues that associations deal with is something called the unrelated business income tax. So what I'm going to do here today is I'm going to give you probably about 10, 15 minutes of kind of background overview on the topic. Because in order to understand this issue of the taxability of income from virtual trade shows, you need to first understand the broader context that it finds itself in. So I'm going to explain that to you. I'll explain this issue. And then the rest of the time, we're just going to keep it open for questions about this topic. And if you have questions on related topics about association meeting contracts and liabilities and cancellations and all the other issues that my colleague and I spend much of every day working on with various associations, feel free to ask about those as well. So for tax-exempt associations, whether they're exempt under 501c6, 501c3, or any other category, those are the 2 main categories that most associations are tax-exempt under. That means that most of your income is going to be exempt from federal and state corporate income tax. Your net income is going to be exempt from paying federal and state corporate income tax. But it's not all income necessarily. It's generally speaking, the biggest category of exempt income is going to be income that comes from activities that are substantially related to your mission and your purpose. So what does that cover? It covers things like membership dues, contributions, conference registration fees, webinar registration fees, things that relate to your mission and purpose of, furthering your industry, your profession, educating, members of your industry on how to do their jobs better, and technical trainings, if you have certification programs for a 501c6 organization, all of these things are substantially related to your mission and your purpose. And so if these are revenue generating activities, and not everything is, for instance, lobbying is not revenue generating, but it's still a related activity. But if it's a revenue generating activity and it is substantially related to your mission and purpose, then all of that income is going to be exempt from federal and state corporate income tax. However, there are certain types of income that associations earn that can actually be taxable under the federal and state corporate income tax regimes. And that has been the case since 1950, since Congress put provisions into the tax code called the Unrelated Business Income Tax. And what these provisions say is that while most of your income may be substantially related to your mission and purpose, if you engage in activities that constitute a trade or business, which means you're carrying it out for, with a profit motive, that's regularly carried on and that is not substantially related to your mission or your purpose, then generally speaking, income from those activities is going to be taxable as unrelated business income, and it's taxable at the same corporate tax rate that for-profit corporations pay, which used to be a graduated tax rate going up to, I think, 30 high 30s. Now it is a flat 21% tax rate since the 2017 federal tax bill. And so if you engage in a trade or business that's regularly carried on, not substantially related to your mission and your purpose, then generally speaking, that income, the net income after directly connected expenses, will be subject to unrelated business income tax. That's fine. You can earn it. You have to make quarterly estimated tax payments, just like a for-profit would. You file a separate tax return with the IRS called the Form 990T to report that income. And it's fine so long as that income in total and aggregate from all your different unrelated business activities doesn't become too great. There are no hard and fast rules on what that means about how much is too much. But if the total income, most people who work in this area will advise that if your total gross unrelated business income starts to approximate 15 to 20% of your total gross income for the year, then you're probably you may be putting your tax exempt status at risk. If you ever get to that point, by the way, and you're really successful in developing some unrelated business income, and it does start to grow significantly, don't cut back on doing it. Just look at other options, such as forming a wholly owned taxable subsidiary and moving the activities into that subsidiary so that you could then engage in those activities on an unlimited basis. Don't ever let the tax laws be kind of the tail that wags the dog if it makes business sense for you to do something. But most associations don't have that much unrelated business income where they get into that situation where they're putting their exempt status at risk. And so earning unrelated business income is fine. You're paying 21% federal corporate income tax. For the states that have state corporate income tax, you're paying a smaller percentage there, but you're still keeping the rest of the money as income, and you're only paying it on the net income, after you subtract directly connected expenses. So UBIT, unrelated business income tax, is not something you should be afraid of or run away from. It's not necessarily a bad thing. Better to earn 70 cents on the dollar than 0 cents on the dollar. But you want to be smart about it. And most associations want to minimize their unrelated business income tax to the greatest extent possible, right? If you're going to earn income, you'd rather have it not pay tax on it than pay tax on it. So how do you do that? Well, one, I already kind of alluded to this, is making sure you're carefully tracking all your directly connected expenses so you can help reduce the net income that is subject to tax. But another way is to either, one, those 3 prongs of that UBIT test, if you can try to make one of those prongs not apply, then all of a sudden the income will not be taxable. So for instance, there's an example, an IRS ruling involving a wildlife conservation society that was selling, C3 Wildlife Conservation Society, selling like desk items, like this is a mouse pad here, like things like that. Although back in the day, they didn't have mouse pads, I don't think, when this ruling came out. But things like that were like emblazoned with a logo, like an image of an endangered species. Now you might say selling desk accessories, mouse pads, pencil cups, things like that. How is that substantially related to the mission and purpose? Well, what they did is they accompanied each item with a piece of literature that was attached to it that had a description of that endangered species, talked about what people could do to help protect that endangered species, and then had information about the organization, how you could donate, get involved, things like that. And what the IRS said in the ruling is that turned what was otherwise going to be an unrelated business activity that was not substantially related to the mission and purpose into a related one, because it furthered that wildlife conservation purpose of the organization. So sometimes you can look at the underlying activity and you can change it in a way to make it a related activity and therefore not subject to UBIT. But if you can't do that, and you're not always going to be able to do that, or sometimes from a business perspective, it doesn't make sense to do that, then another option is to see if one of the many exceptions to unrelated business income apply. So there are all these different exceptions in the tax code, so that irrespective of the 3-part UBIT test, if you fit the income into one of these exceptions, then it's not going to be taxable. It's going to be exempt from MUBIT. So what are some of these exemptions? There's a whole bunch of them. Some of them are not really applicable to associations, but some of the ones that are more common is an exception for interest, for dividends, for annuities. There's an exception for royalties, which are monies that you get from licensing your intellectual property, like someone else gives you money to use your logo on their products and they pay you a percentage of sales. If you're not doing anything else, like you're not doing marketing on their behalf or anything else, then all of that income will be tax exempt as a royalty, which it's an exception that associations take advantage of all the time in various endorsed kind of affinity programs and things like that, and in other ways. But any intellectual property, trademarks, copyrights, et cetera, that you let someone use for a fee, that's going to fall under the royalty exception. There's also an exception for what are called qualified corporate sponsorship payments. So corporate sponsorships, you're probably familiar with them, very common in the association world. This is where a corporation comes along and says, look, we want to sponsor this event, or we want to be a sponsor on your website, or we want to sponsor this golf tournament. And you acknowledge our sponsorship with some signage, some whatever else, and in exchange, we'll pay you this sponsorship fee. This is the most recent exception to the unrelated business income tax. It was written into the tax code in the mid-90s after a whole bunch of litigation in this area. And it's a pretty big exception that's very widely used. And there's actually some rare but very helpful detailed guidance and regulations from the IRS in this area that say what sort of acknowledgement can you give to a sponsor while not, while still fitting within this exception. Things like you can use the sponsor's logo. You can use any established slogans. You can have a link to their website, at least the main landing page of their website. You can have contact information. You can have non-qualitative descriptions of the sponsor's products and services. These are a lot of things you can do that are all consistent with this exception, this corporate sponsorship exception. But then the regulations say if you do things like include price information about the sponsor's products, if you have endorsement type language, if you have qualitative descriptions of the sponsor's product or service, they're the best, the least expensive, the most efficient, whatever qualitative language, those things are not consistent with the exception and will likely cause some of that income to turn into taxable unrelated business income, not necessarily all of it. Anyway, that's not the focus of today's program, but these are all interesting and important exceptions. And by the way, for those of you who are interested, I have articles on our firm's website on all of these topics. Unrelated business income generally, royalties, one on corporate sponsorships, a number of other things. So if you're interested, let me know, or I can probably send you guys some links to forward on to the group here. But then there's some of the other exceptions, one for capital gains, one for rental income from non-debt financed property. There's one, the volunteer labor exception, if 85% or more of the labor of the activity is conducted by unpaid volunteers. That's another exception. But the one that we're focused on here today is the qualified convention and trade show exception. That one has been around since 1976. It came about through a lobbying effort by the association community primarily, in the U.S. Chamber of Commerce, because at the time, the IRS was trying to tax the income from association trade show booth sales as unrelated business income. Basically, so the most common form of unrelated business income is advertising income. There's a theoretical narrow exception for a certain type of advertising income, but it's almost impossible to meet. So the practical reality is advertising income, advertising in your newsletters, your magazines, your journals. That's almost always going to be taxable as unrelated business income. And what the IRS was saying back then, early 70s, was that trade show booth income was equivalent to advertising. The booth sales, or the booths are being sold, exhibit booths, to companies that are advertising their products and services at your conferences and trade shows, and therefore that income should be taxable. And it's not an irrational argument that the IRS was making, which is why it took a lobbying effort in Congress to step in to create an exception to unrelated business income for qualified convention and trade show activities. Now, that exception has always been viewed very broadly to essentially exempt virtually all income that comes from the typical association conference and meeting. There are some detailed rules about the structure of the conference and what it needs to look like. But generally speaking, most trading professional association conferences fit the bill and fit within that exception. And what it does is that, at least in the past, we've always thought it exempts virtually all income, with the only exception being if you have advertising in like a program, book, brochure, whatever at the conference, then that advertising income is likely still going to be taxable. But virtually all other income is going to be tax-free, including exhibit show booth fees that are paid by exhibitors. However, back in, what year was it here? 2005, or actually I think it came out in 2004, the IRS came out with a ruling, and they had actually solicited comments. It's called a revenue ruling. They had solicited comments on it for months earlier. And then they came out with a ruling about, back then, what they called, and what we still call, virtual trade shows. Although back in 2004, this was kind of the really beginning of virtual trade shows. And the way, and it was just before this, looking at my book to see exactly how the exception for qualified convention and trade show income is written. I'm kind of revisiting that. And when you read the detailed rules that exist for it, there's nothing in there that explicitly says the convention or trade show has to be an in-person event. But you could see how it could be interpreted that way. I think you could equally interpret it, a different way. But back then in 2004, the IRS in this revenue ruling basically said, for this exception to apply, it applies to in-person trade shows and trade show exhibit fees and whatnot at in-person shows. And they said for a virtual show, though, basically they created this dual construct. So one construct is, and they actually gave two different examples. And they said in the first example, you have an in-person trade show, and then you essentially have a parallel virtual trade show that's going on at the same time. And in the example, I think the virtual trade show started 3 days before the in-person and then went to 3 days after. So it kind of overlapped. But it was basically just featuring exhibitors that were exhibiting at the in-person trade show. So it's kind of enhancing the in-person trade show, and what the IRS called it was the way the online activities were ancillary to the in-person trade shows. They said if companies are paying extra to be in the virtual trade show component, that was covered by the exception, and that was not going to be, that would be exempt under the qualified convention and trade show exception. But in the other example, it was a virtual only trade show that did not involve an in-person component. And there, the IRS concluded in this revenue ruling that the qualified convention and trade show exception does not apply to revenue from that virtual only trade show. That's the only guidance the IRS has issued on this. That was obviously 16 years ago. The world of technology has changed mightily since then. The ability to do things like networking and education and whatnot online has changed significantly since then. It's unclear whether the IRS, if they were opining on these issues today, would rule the same way and interpret this exception the same way. But this is what we have to deal with. This is the only guidance that exists. It's very specific guidance. IRS oftentimes doesn't come out with very specific guidance in the exempt organizations area. It's kind of rare. And this is what we're stuck with. There's a lot of open questions, right? That example of, the virtual trade show starting 3 days before and going to 3 days after the in-person show, if the period was even longer, like months, how would that affect the analysis? We just don't know. So the bottom line here is that if in the COVID era, a lot of associations, most associations have canceled, virtually every association has canceled their in-person conferences that were scheduled for 2020. Many are already canceling their 2021, at least early 2021 conferences. And of course, many have switched to a virtual conference, including a number of them having a virtual trade show component to try to offset some of that lost revenue. Right now, the guidance out there that exists would strongly suggest that income from the virtual trade show, now we're not talking about the entire conference registration fees, but income that you get from exhibitors who are exhibiting at the virtual trade show, the prevailing analysis would suggest that is not covered by the qualified convention and trade show exception. Now, last point, and then I'm going to open it up for questions. Just because something is not subject to the exception doesn't automatically mean that it's going to be subject to unrelated business income. So same thing goes to corporate sponsorships. I get this all the time. Even I gave some quotes to a reporter who was writing an article on this for a meetings industry newsletter, and he incorrectly wrote in the article that if income was not subject to this qualified convention and trade show exception, then it was automatically taxable as unrelated business income. And that is not the case. That is absolutely not the case. This means it's not subject to the exception. So then you say, A, is it subject maybe to another exception? Or B, can we somehow look at it? We apply that three-prong UBIT test and see how it plays out. So in this situation, as I told someone from ASAE who was writing an article about this, it's about as clear as mud. It's really, really unclear, and it's really, really difficult to analyze. But I will give you a few ideas. First off, if it's possible, and it may be possible, depending on the nature of the benefits that the company's getting and whatnot, you may be able to restructure and retool this into a corporate sponsorship as opposed to a virtual trade show exhibit. It might be difficult, but there might be a way to shoehorn it into that corporate sponsorship exception. The corporate sponsorship exception, by its terms, does not apply to qualified convention and trade show activity. However, if this is not qualified convention and trade show activity, then the corporate sponsorship exception should apply in the virtual conference and the virtual trade show world, and you might be able to restructure this as a corporate sponsorship. And then secondly, you have that three-prong UBIT test. It's going to be likely very difficult based on the precedent, including a U.S. Supreme Court decision back in 1986. It's going to be really difficult to try to say that virtual trade show exhibit fees are substantially related to the association's taxes and purposes. But if this virtual trade show is a one-time thing that you're just doing this year, maybe next year, but not after that, once hopefully COVID is behind us, then you might, I think, have a strong argument that it's not regularly carried on. This is not a regularly carried on activity. This is a one-time or two-time, one or two and done. And therefore, if it's not regularly carried on, it doesn't meet the three-prong UBIT test. Therefore, it's not going to be taxable. So that's a long-winded, close to 25-minute explanation of the basic background and context and rules in this area. So why don't I stop there and see what kind of questions you guys have. Not seeing any specific questions so far. So you guys got to chime in and throw some questions at me. Like I said, on this area, but if you have other questions on COVID-related legal issues for associations, areas that I spend much of every day on involving meeting contracts and meeting liabilities and office reopenings and the liabilities there. If you have questions on any of those things, feel free to ask as well. Come on, you guys are awfully quiet today. Is ASAE considering addressing the IRS rule with so much going virtual? I've had discussions with ASAE about this, and with Mary Kate Cunningham in particular, the head of their public policy division. They're very well aware of this issue. And like I said, they wrote an article all about this that they interviewed me for. The problem with the IRS is that it's like moving a mountain. They are, and more so today than in all of the 25 years that I've seen the IRS work in the exempt organizations area. They just don't, they're not going to do anything. And it's virtually impossible to have any kind of lobbying effort be successful to get there. So I would not hold your breath for any new guidance. And even if they did, I'm not sure they would come out any differently on the analysis. They might say, look, if you have an issue on this, go to Congress and get Congress to amend the statute. And that's, frankly, a more viable option if there is, some big tax bill next year, which there very well might be. Getting some small modification to the legislation, just like ASAE was instrumental in helping getting this written into the tax code back in 1976, is not at all improbable. But it's too hard to say right now. What are the biggest risks for taxation of associations? I'm not sure exactly what you mean by what are the biggest risks. I mean, the biggest risk is that you lose your tax exempt status from having things like too much unrelated business income or private inurement, or for 501c3s, impermissible private benefit, or for C3s, you engage in prohibited political campaign activity or too much lobbying activity. I mean, those are the things that can risk your whole tax exempt status. So from a threshold issue, those are the biggest risks. I'd say in terms of just the day-to-day issues that most associations deal with, these unrelated business income tax are the things that I counsel associations on the most. In terms of trying to structure activities to try to mitigate unrelated business income, so you're paying as little as possible. There is one thing. There's another IRS ruling that came out maybe a few years after this other one that basically said that for associations that run certification programs, if you run a certification or accreditation program through a 501c3, all of that income is likely going to be taxable as unrelated business income. But if you run it through a C6, it's likely not going to be. Just something to keep in mind. To clarify, what actions are most likely going to be seen as taxable? So I think you got to analyze each one of these separately in different areas. But in short, what usually is going to generate taxable income is when the association is doing things to help market and promote a particular company and its products or services, whether it's in connection with an endorsement or affinity deal, or whether it's in connection with a corporate sponsorship arrangement, or other things like that. When the association is getting paid to market that company's product or service to usually to the members of the association, that is going to be akin to advertising income, and that is almost certainly going to be taxable. And of course, advertising income itself is virtually always taxable. Is it correct that UBIT can also be offset by expenses directly connected to the activity? Yeah, I said that earlier. Absolutely. And that's really important for tracking expenses that are directly connected to the generation of the income, to directly connected to the carrying on of the activity. If you can track those direct and indirect expenses, you can use those sometimes to really bring the net income down to a much smaller level. So you might have $100,000 in gross unrelated business income, but if you can get the net number down to $40,000, you're only paying tax on $40,000 instead of $100,000. So it makes a difference. Just keep in mind, though, that is one area the IRS has been aggressive over the years, including recently, looking at your expense allocations to make sure you're not over applying expenses against unrelated business income. And in addition, there was some in the 2017 tax bill, there were some tweaks to the unrelated business income rules or legislation. One of them, like I said, reduced the tax amount down to a flat 21% tax rate, which was a good thing. But there were some other changes, like for instance, just like in the for-profit tax area, you can have what are called net operating losses, where if you have a loss, like your expenses exceeded your income in a given year, there are rules that allow you to carry forward those losses to future years to offset future years' positive net income. But the IRS has really cracked down on that, in that if you do that repeatedly year after year, there's a very good chance they're going to disallow some or all of those net operating losses. It's kind of hyper-technical why they do that, but just keep that in mind if you're in that situation, and just be careful. You want to have reasonable and consistent and defensible methods of cost allocation when you're allocating expenses against that income. If the promotion is tied to member benefits, is it considered UBIT? So, again, this is a classic area, like in the, I was working at ASAE when I went to law school at night, the beginning of my career. And back then, these issues involving royalties, I talked about the royalty exception, were really big. There was a lot of litigation, a big seminal tax court case involving the Sierra Club that Sierra Club won. And back then it had to do with, basically that had to do with affinity credit cards, where you see it all the time. The nonprofit's logo is on a credit card. Credit card is marketed to the members or supporters or donors of the organization. And then so the association or the nonprofit is licensing its logo to the company to use, say, on the credit card. They're often licensing their membership list or donor list as well. And then they're getting paid a fee. Usually for a credit card, it's often like, a couple percent, 1 or 2% of the gross purchases made by the association's members get paid to the association as a royalty. And the issues in those cases had to do with if the association or nonprofit is asked to market or promote this benefit to the members, which they always are, because the for-profit company, could do its own marketing, but it's much more powerful and much more effective if it comes from the nonprofit, from the association itself. So as part of these contracts, and I work on these all the time, the companies are often asking for the association to do marketing, like through member benefit programs and whatnot, to market this to the members. And so to the extent you are getting paid to do marketing, that is, some portion of that payment is going to be treated as taxable unrelated business income, because it's essentially a marketing fee, really no different than advertising revenue. But back then, the question before the court was, if some of that is marketing, therefore not all of it is going to be royalty income, did that taint the entire amount of income so that it was all going to be treated as taxable income? And what the court said was no. You can divide it up. So clearly, some part of what you're getting paid for is the right to use your name and logo. That part is going to be tax-free royalty. But some other part is going to be money that you're getting to market the company's product or service to your members. That part is generally going to be taxable unrelated business income, but you can have both coexist. In the beginning, for years, lawyers like me used to advise clients to divide it up into two separate contracts between the association and the company, one for the royalty, the licensing part, and one for the marketing services. That generally is not needed anymore. Most people don't advise it. But what I do advise is in your contracts, have two separate sections. One is the licensing part for the royalty, and the other is the marketing part that's taxable. And allocate the revenue stream between the two, either on a dollar or a percentage basis, however, and it's got to be a fair market allocation. Okay, I see there's a non-tax question, which I'm going to address. I don't see any other tax questions. So let's move on to this. We got about 10 minutes left. If an employee contracts COVID and sues the employer, how does the employee prove where they contracted the virus? What's the likelihood of liability? So, very interesting issue from a legal perspective, and an issue that many employers are going to be dealing with in 2021, as a lot of employers have their employees come back to the office, which largely hasn't happened in the association community, at least on a mass scale. Certainly hasn't. Some pockets here and there, some employees in some associations, but not most. Most are still working remotely, but there's a high expectation that that is going to change in 2021. And so the question is, an employer requires its employees to come back to the workplace. An employee contracts the virus and sues the employer, saying that they contracted it at the office or during work travel or something, and that the association was negligent in how it operated the workplace, how it allowed work travel to occur, and therefore should be held liable for any of the damages that flowed from contracting the virus, medical bills, pain and suffering, all the rest. We've already seen these claims, not in the association world, but with other employers, a lot of like the meatpacking plants and others that you've all read about. There's been a lot of class action lawsuits like that in those situations. One of the articles that I've written during the pandemic is all about liability for workplace reopenings. It talks about what's the whole liability construct here, the basic ground rules, and then what can you do to mitigate your liability risk. First off, causation is a big issue. And there's a lot of litigation going on right now, like I said, and that's one of the big issues in the litigation is how can the employee prove that they contracted it at the office, so to speak, or at the workplace. And if it's a one-off employee, a single employee contracting the virus, it's going to be difficult, if not impossible in most cases, to prove that it was contracted at the workplace or during work travel. If it's a cluster of people, though, and we have seen that in certain workplaces, it's going to be a lot easier to prove causation. Now, what about liability? What's the likelihood of the employer being held liable? Well, the basic construct here is, was the employer negligent in not meeting the prevailing standard of care that exists at the time? What is the prevailing standard of care? Well, this is a legal term. It comes from tort liability for negligence. And it's a moving target, basically. It's going to change all the time, and it comes from lots of different places. Some of it from law, some of it from other things. So you always start when you're looking at what's the standard of care, you say, is there anything that's legally required and mandated or prohibited? as you probably know, there really are no federal mandates when it comes to things like this. There's a lot of federal guidance, and I'll talk about that in a second, but there's no federal mandates. There are, however, some state and local, like city and county mandates that say, if you're going to reopen your offices, or you're going to have people come into the office, these are certain things you have to do or you can't do. So you always start with what's legally required or prohibited. That's where you start the analysis, but it doesn't end there. You then look to see what other kind of prevailing guidance is there out there, recommendations on this stuff. And for workplaces, you start with the primary federal regulator of workplaces, that's OSHA, the Occupational Safety and Health Administration. My article links to the two primary pieces of OSHA guidance on this. Again, it's recommendations, it's not binding, but it's very detailed and it's very helpful because it essentially establishes the standard of care for what employers should do to create a safe workplace for their employees. And essentially, you want to follow as many of those things as you can practically afford and feasibly implement in your workplace. The more you do those things, the less likely and the more difficult it's going to be for someone to prove that you were negligent in how you operated your workplace. In addition, a couple other things to keep in mind for now, at least until we're at a very different point, at the tail end or past this pandemic. I strongly recommend that you make any return to the office voluntary. Don't force people to come back, unless it's absolutely an essential function of the job and there's no other way around it. You generally want to make it voluntary. There are lots of different reasons, some of which are protected by law, medical issues, religious issues, other issues, disability issues, where people literally may not be able to or feel comfortable coming back to the office in this environment. Make it voluntary. Do not penalize people. Don't demote them. Don't not promote them or give them a raise or anything else like that because they choose to work from home. So make it voluntary, make the work travel when that starts to happen more voluntary. And then finally, another thing to keep in mind is that most claims in most states, this is very much state regulated, state by state, so it varies a bit. But in most states, most claims by an employee, like lawsuits, have to go through the workers' compensation system that state has created. For which virtually every employer has workers' compensation insurance, which covers the costs of defending and paying out those claims. And it really limits the potential liability of the employer. And so from an employer perspective, that's a good thing. Now, I will say that a number of states, I think last count, there were 13 states so far that had already made changes to their workers' compensation laws to actually provide additional protections for COVID to employees. And so that's going to be something to keep an eye on. But the good thing from an employer perspective is that unless, generally speaking, and there's always exceptions, but generally speaking, unless the employer engages in gross negligence or willful misconduct, most claims are going to go through the workers' compensation system, which is going to significantly help to reduce the employer's potential liability and should be covered by insurance. It's actually one of the only, I just came off an ASAE panel literally right before this about insurance issues for associations in the COVID era. And, one of the big takeaways from that panel was that workers' compensation is really the only insurance policy these days that will cover COVID-related claims. Virtually everything else is not going to cover COVID claims, from new event cancellation insurance policies to commercial general liability insurance to business interruption insurance and everything else. It's kind of the only one. So there is some reason to feel more assured on the employer front in terms of liability, but it's not a reason, it's not an excuse to not do all those things to create, the safest environment possible, both to protect your employees, but also to protect the liability risk of the employer. And one other issue that I get asked about here, what about having our employees sign a liability waiver that they won't sue us if they contract the virus at work or during work travel or work events? Most states say that it is illegal for an employee to waive their workers' compensation rights. So in vast majority of situations, those liability waivers are going to be null and void in the employment context. Very different from the convention and meeting context, where another article I wrote about how to minimize your liability risk from holding in-person events next year. There I talk about liability waivers and how they can be a helpful tool in the toolbox mitigating the liability risk of associations for talking about having your attendees sign liability waivers. But there, it's a completely different legal construct than for employees. And I see someone ask about sharing these articles. Yes, I will share probably this evening. I'll pull together these various article links and send them off so that they can be shared with you guys. And I think we're about at the end of our program, and I think we're at the end of all of our questions. So hearing or seeing no more, thank you guys for a pretty deep dive into some pretty nuanced technical stuff, but hopefully I was able to explain it in a way that made some sense, and hopefully the articles will help elaborate on these things a little further.
Thank you so much. We really appreciate you taking the time to be with us today. I just posted a direct link so you can click on that and head to your next session. Don't forget you can scroll down to download the handouts that were provided by Dr. McAllister, as well as any of the speakers that you've heard today. If they provided handouts, they're on each of those class pages. Jeff, thank you so much for being here, and we are off to our next session.
Thanks for having me. Bye, guys.